Good evening, Commission members and Mr. Chairman. I have two parts to my presentation. I'm going to get to this constitutional paper that I gave you in a few seconds. If I don't know how much time I have up here.
Take your time, Ron.
Like most of you gentlemen, your backgrounds precede you. That's why you're on the board here. But my background is I have a broad academic background in engineering and life sciences. And I've had a lot of career changes, and specifically I'm a physicist and an electrical engineer. And I've been right in on this process right from day one. I go to all the site board meetings. I've been through the Invenergy docket dozens of times. I'm with some of my fellow citizens looking for holes in the process and trying to exploit them. And basically what happens is when you're an expert in a field, you tackle a project, you have to look at it in a comprehensive manner. But at the same time, you have to look at the minutia, the details. So what we have at the siting board is 3 siting board members, no doubt experts in their field, but they have to deal with expert testimony from dozens of different other disciplines. And going into these data requests and data responses and advisory opinions, you can see, even in some of the minutia, some of it's full of holes. Now, someone up on a siting board, under constraint of time especially, is going to gloss over the details because there's just not enough time to absorb it. And they might not even be able to absorb it, so they rely on expert testimony. And these experts are under oath, it's testimony, and so you trust what they're saying. And that's how they have to make their decision. But beneath that, if the testimony itself is based on, for example, in some instances, data and parameters provided by the Invenergy company, for example, where they're making their decisions and their advisories on data they're kind of regurgitating the data that they've been given. It's like, it doesn't matter how great your statistical modeling or whatever computer program you're using, like for different analysis they use. Ultimately, if you put garbage into the modeling, you're going to get garbage out of the modeling. Or they can put the parameters in that they want to get the results that they want. And it's going to go right by the people on the siting board. And in that regard, we look at other states. They have 9, 10, 11 members. They have the ability to more liberally call in expert testimony that is neutral rather than biased, like the company has its experts, but they pay for those experts, and the town has their experts. There might be some bias there, I don't know. But to have neutral experts and be able to liberally call them in, I think, because basically 3 people can't handle that alone. They're just going to gloss over things and maybe make decisions on other bases. But, okay, that's my feeling on that part. But this part here, I haven't heard any of this, but I did hear it from Mr. Mancini tonight about local control and all that kind of stuff. I just want to say that the Constitution of the state of Rhode Island was written before the Siting Act. So I'd like to refer to Article 6, Section 1. The Constitution shall be the supreme law of the state, and any law inconsistent therewith shall be void, and the General Assembly shall pass all laws necessary to carry the Constitution into effect. Now, Article 13 of the Constitution, Home Rules for Cities and Towns. Section 4, Powers of the General Assembly. The General Assembly shall have the power to act in relation to the property affairs and government of any city or town by general laws which shall apply to all cities and towns alike. So maybe that's where some of this don't give too much control to local mentality sort of idea comes from. But if you look at the Energy Facility Siting Act itself, I left out all the findings and all that because that's like 2 pages long. But the licensing decision issued by the site board shall constitute the sole, final, binding, and determinative regulatory decision within the state for the purposes of siting the facility. All right, I don't think there's any doubt that complies with Article 13 of the Constitution. I mean, it's like the DEM. You make rules for the whole state. You make licenses and permitting authorities that apply to everybody alike throughout the state. But like The Energy Facility Siting Act is like a hybrid legislative animal. In reading the second part of Article 13, this is a selective quote, "The General Assembly shall also have the power to act in relation to the property affairs and government of a particular city or town, providing that such legislative action shall become effective only upon approval by a majority of the qualified electors in the said city or town at a general or special election." The Energy Facility Siting Act, as I read it in plain English, doesn't satisfy the second part of Article 13. Now, constitutionally, like we say, that we need the central. I think the EFSB is a good idea. I mean, there are all kinds of overlapping agencies, and there is all kinds of issues of people, opposed or not opposed and all that. But the Siting Act itself was written way after the Constitution was it. And if the Siting Act does not comport with for example, with Article 13, because basically, even though you're regulating the plant, the final act of physical construction of that plant is the General Assembly acting towards a particular city or town. In which case, to do that, they need the permission of the people of the town. And if that doesn't happen, then by Article 6, the Energy Facility Siting Act is void. See, from my point of view, the Energy Facility Siting Act, the way it is right now, is null and void. And I know there's going to be a lot of disagreement about that. But if somebody would mount a constitutional challenge, it's up to the court to decide. And I can see the signatories of the Green Map becoming plaintiffs in such a suit. Or I can see the town of Burrillville maybe having a special referendum symbolically, and then using that as ammunition in the constitutional case in the Supreme Court. And that's basically how I put it. So,
Thank you, Mr. Keegan.